welcome everybody. This is our second session of ABODE Academy 2, and tonight's session is called A Good Death. It's all in the details. And tonight we're going to talk a little bit about the legal aspects of dying and getting your affairs in order and making sure people know what you want and that how do you put that in writing so that your wishes are followed. And tonight's wonderful speaker is Carol Bertsch. She's an attorney in elder care. And a couple things before we start. I don't know if you've heard, Carol sponsored some spots on TPR that promoted ABODE Academy. And if you heard those, they were wonderful. And we sure thank you, Carol. And if you haven't heard them, just keep listening to TPR because we have a future program that by Sunny Markham, and she also sponsored some spots on TPR. So listen for those as well. They're really fun to hear, giving us a shout out. Last week's session, if you didn't attend or if you did attend and want to hear it again or have friends or family members that want to hear it, it's already on the website. So just go to the ABODE website under education and you'll find the link to hear last week's session. And tonight's session as well will be recorded and we will store it on the website and you can hear it again. And I just hope we can get the word out because this is really, really important information. If you haven't attended before or been on Zoom, we hold our questions till the end of the session. So if you want to, right in the center of your screen towards the bottom is a little chat box, and just hit that and you can type in a question, or we'll take some questions at the end. And you know, if you're shy of typing, we can listen to your question. But if you want to type in a question, just do that and we'll go over those at the end of the session. And also in the Zoom link email you got, there was a downloading attachment that we all got for an example of the Directive to Physicians. If you haven't printed this, if you can do that, she's going to go over this piece by piece, so it might be easier to follow if you have a copy in front of you. So what I'll do now is I will welcome our speaker for tonight, Carol Bertsch. She is a really old soul. You can see it in her eyes when she listens intently to what you need and helps you evaluate all your options. She treats her clients with dignity, patience, and understanding, and will make house calls to those that are unable to visit the office, which is always wonderful, especially in this day and age. Carol Bertsch is an advocate for seniors in our community. She holds a Doctor of Jurisprudence degree from the University of Texas at Austin School of Law. In 1996, Carol started her elder law practice in San Antonio to assist seniors and people with special needs and their families as they plan for challenges surrounding aging. When Carol's not working, she's trying new restaurants with her husband and visiting her mom and her siblings. She's also a mentor for the Through Project. So what I'd like to do now is welcome Carol and we'll get started. Thank you.
Thank you, Beverly. So hello, everybody. I'm just so grateful to be here and so proud to be, I'm honored to be a speaker for ABODE Academy 2 and a speaker for ABODE, the organization. I really respect what ABODE does. So let's talk a little bit about the preparation that we need to do for legal documents. And I'm going to start with the Directive to Physicians, but the Directive to Physicians, that's the document that got emailed, is not the most important document. And I say that because the Directive to Physicians is a very narrow document. It only applies if you are incapacitated and in a terminal or irreversible condition. So it's very narrow and you only have two choices. I do want life-sustaining treatment if I'm in this situation, namely incapacitated and terminal or irreversible, or I don't want life-sustaining treatment. So the directive to physicians, it's important in that it lets your family know whether if you're in a terminal or irreversible condition, you do want life-sustaining treatment or you don't. But what about all the other situations that you might be in, medically speaking? And what about all your other choices? Those issues are addressed with the medical power of attorney. The medical power of attorney is the document that I think is most important. Now, you may be asking yourself, Carol, why didn't you send out the medical power of attorney since you think it's the most important? Well, that would have to do with my inability to find it on my computer today when I was sending documents to Mary. So forgive me, I'm sorry. I couldn't find a blank one when I needed it, but I did find a blank directive to physicians. So I sent that out to you just so you have it. But remember that the medical power of attorney is your most important document. Why is that? Because your medical power of attorney appoints someone to make medical decisions for you in all situations other than you being incapacitated and in a terminal or irreversible condition, and whether you want life-sustaining treatment or not, okay? The directive to physicians is important because it saves your family having to make an agonizing decision, but your medical agent, that's what we call the person who makes decisions for you under a medical power of attorney. That's your medical agent. Your medical agent can also make that decision if you don't have a directive to physicians. The important thing to do is to have a conversation with the person who you appoint as your medical agent. And let's talk for a minute about how we know who to appoint. It's not, oh, I have to appoint my oldest child because he's my oldest child. No, when we're appointing a medical agent, we're looking at who can be an advocate for us and who can be outspoken for our wishes, who can deal with the medical providers and say, no, that's not what mom wants, or yes, that is what my wife wants. That's your medical agent. That's who you choose. Your medical agent can be anyone. It doesn't have to be a family member, although it's handy sometimes to choose a family member. It doesn't have to be your spouse. It doesn't have to be your oldest child. It can be whoever fits the need, has the skill set that we're looking for, okay? And the skill set, again, is they can be an advocate for you, and also that you feel comfortable having.
Oh, let's see. The internet pooped out on us, right? Or is it just me?
No, it did.
It was,
There we
I
go.
froze. Sorry about that, y'all.
That's okay. That's okay.
I'm really working hard on my internet connection because it freezes, and my IT guy has come over and tried to fix it, and we've had trouble, and I apologize. If it happens again, y'all just talk amongst yourselves about how wonderful I am. So
We'll do it.
thank you. What I was going to say, or what I was saying, was you choose your medical agent based on who can be your advocate and who you feel comfortable having conversation with about your medical wishes, about what is most important to you. Okay. So the person who you choose for your medical agent, and remember, you're always going to choose an alternate. You're going to have a primary, an alternate, and even a second alternate, because we never know what's going to happen in life. We never know when our agent is going to get pancreatic cancer and die 2 months later. So we've got to have an alternate. We want to have conversations with that person about what's important to us, about what we value, because that person is going to have to make medical decisions for us if we become incapacitated. And those medical decisions are going to be based on, your agent makes those decisions based on what you would want. Okay? So let's go back to the directive to physicians and remember that a lot of people think, oh, I have a directive to physicians. That means that if my heart stops, I won't get CPR. They get it confused with the do not resuscitate order. So let's clarify the difference between those two. The out of hospital do not resuscitate order, or DNR, is a very specialized document. Let me explain. All of us should have a medical power of attorney. All of us should have a directive to physicians, because we never know what's going to happen and when we might become incapacitated. But all of us don't need an out of hospital do not resuscitate order. An out of hospital do not resuscitate order means if my heart stops beating or I stop breathing, I don't want EMS to resuscitate me. If I die, I don't want to come back to life. Okay? The do not resuscitate order is what controls that, not the directive to physicians. The directive to physicians applies to life-sustaining treatment, such as a feeding tube or a breathing machine. But you're not dead, you're alive, and you're saying, if I need a feeding tube, I don't want one, or I do want one, because you get to choose which way you want to go. But the do not resuscitate order says very specifically, if I die, leave me dead. Okay? So if you have any questions about that, I'll answer them at the end, but it's easy for people to get confused between the two. And the directive to physicians, I've meant to say this earlier, is what a lot of people call a living will. But the directive to physicians is different from the do not resuscitate order. Okay. Well, if we've got our medical power of attorney and we've got our directive to physicians, is there anything else we need? Yes, indeed. We also need a financial power of attorney. The financial power of attorney is very important because it allows you to appoint someone to handle your finances if you become incapacitated. If you become incapacitated, either you're so ill and on morphine that you're incapacitated, somebody needs to be able to pay your bills for you. Somebody needs to be able to talk to the insurance company if that needs to be done. All of those things are done by your financial agent. That's the person who is named in your financial power of attorney. And again, we need a primary, an alternate, and even a second alternate, because you're going to do these documents while you have capacity. We all need them because none of us know when we might lose capacity. So we do them now. But if we do them now and we don't need them for 5 years, there's no telling what might have happened to our agents in that 5 years. That's why we name, as I said before, a primary, an alternate, and even a second alternate. It's very important. And if you don't have that many people in your life who you can trust, then we may need to think about other options. But you still need to have, you can't just say, oh, I've got one person and I'm going to name that person and I'm done. That's not sufficient. So the other document that we need to talk about is a will. A will is a document that is only effective after your death. The documents I talked about before, the medical power of attorney, the financial power of attorney, the directive to physicians, those documents are effective during your lifetime. Your will is effective after your death and after it's gone through probate. Important for people to know. They think that, oh, I did a will and everything's finished, but it's a two-step process. The will gets written and signed, and then after your death, your executor probates your will. That means that the executor submits it to the court and the judge says, yes, this is a valid will. It hasn't been forged. It's not subject to undue influence. Then your executor has authority to act for your estate after the will has been admitted to probate. Something I always want people to understand is you have 4 years from the date of death to submit a will for probate. You cannot probate a will after 4 years. Well, let me take that back. You can probate a will after 4 years, but it's more difficult, number one, and it's limited, number two. So best to go ahead and do it within the 4-year time frame. If you don't do it within the 4-year time frame and we can't probate the will, that means that your estate is going to pass as if you didn't have a will. So I have a family right now who, when dad died, they just assumed everything passed to mom. That's what dad said in his will. They didn't know that the will had to be probated. So they didn't do anything. And that was back in 2012. Well, now we're in 2021 or 2020 when this family came to me. And we've got to do some extra steps and talk to a bunch of heirs, potential heirs, and make sure that they say, yeah, it's okay for you to probate that will because we didn't do it at the time. Just because you're married to someone doesn't mean that everything automatically passes to you. Because we're a community property state, your spouse can leave your spouse's share of everything to whoever she or he wants. So let's say that I'm married and I die. I leave in my will everything to my boyfriend over here, and my husband doesn't get anything. Now, just so you know, I didn't leave everything to my boyfriend. I left half to my boyfriend and half to my husband. No, that's not true either. Anyway, let's see. I got all distracted talking about my boyfriend and now I forgot what my point was. It was that you don't assume that everything passes to your spouse in Texas. Other states are different. So you may have come from a state where everything did pass to the spouse automatically. But every state is different. Texas doesn't do that. You want to have a will. You want to probate it within 4 years. What happens if you don't plan? What happens if you don't do a financial power of attorney, for example? Or what happens if you don't do a medical power of attorney? Then what we might end up with is having to go to court and getting a guardian appointed. We don't want to do this because guardianship is expensive. It is time consuming. It is cumbersome. We want to avoid guardianship, and we can avoid it by having powers of attorney. The thing about guardianship is you've got to pay a lot of attorney's fees. For some reason, I don't understand why, people don't want to pay lawyers. I think paying lawyers is probably next highest to ABODE, contemplative care for the dying, paying lawyers, right there. But other people don't feel that way for some reason. They think paying lawyers is bad. If that's you, then do your powers of attorney, because otherwise your estate is going to be out a lot of dollars paying lawyers to get you a guardianship. People ask me, Carol, how come I have to pay a lawyer to do a financial power of attorney? Or do I have to pay a lawyer to do a financial power of attorney? Well, I know it's self-serving, but personally, I think that you should pay a lawyer to do a financial power of attorney. Now, a medical power of attorney and a directive to physicians, you can do those without a lawyer. You need to be careful. You need to follow the directions and read it carefully. You can't just willy-nilly say, oh, here, I'm going to fill this out. You got to put the names in the right place, put the address in the right place, sign it with a witness, get it notarized, that kind of thing. Financial power of attorney is a little bit different. It's more complicated. And if you don't do it right and you become incapacitated, we may not be able to do everything for you that we'd like to do. So I recommend that you see a lawyer for that. For your will, can you do it without a lawyer? Yes, you can. Should you do it without a lawyer? If you want your estate to pay more in attorney's fees, you should definitely do it without a lawyer, because it's probably going to come out of your estate when you did something wrong. What am I talking about? Well, a lot of times people think, I'm writing this down, I'm writing my will, and this is very clear. I want everything to go to so-and-so. But what about if so-and-so doesn't survive you? Well, I want everything to go to so-and-so and then to his son. Well, does that mean that you want it to go to so-and-so for life, as a life estate, and then to his son? Or to so-and-so outright and only to his son if he predeceases? It's easy to be ambiguous if you're not careful and if you're not thinking of all the possibilities. So you write your own will thinking that you did a nice, clear job, and then your grandson sues his father and says, no, grandma didn't mean she wanted you to have it outright. She meant you got the ranch while you were alive, and then it comes all to me. Am I making this up? I am not. That's a probate, the contested probate case. And the court in that case said, you know what? It's yours for life. And then it goes to son. So, or to grandson. So son was a little bit pissed off, pardon me, a little irate, because he didn't get the ranch to do with what he wanted. He had to get it for life, and then it had to go to his son, grandson. Okay. So when you're doing a will, if you're not using a lawyer and you think you're being very clear, just think again, because you don't get to go back from the grave and clarify when it's in the courtroom. You don't get to haunt the judge or have a seance and come to the judge during the nighttime in a dream and say, what I really meant was this. And even if you do come to the judge in a dream, the judge isn't going to use that as evidence. I can just see the judge now ruling from the bench. Well, in a dream, Beverly came to me and said that she wanted everything to go to Carol Burch, which is exactly what Beverly wants. That's my plan anyway. Okay, so hang on, I got to check my notes. Did I cover what I needed to cover? Disasters I've seen. What happens if you don't plan at all? Okay. A lot of people ask, how much does it cost? Why should I pay a lawyer? I've had folks who don't want to pay a lawyer because they want everything to go. They don't want to spend money on a lawyer. They want everything to go to their children. Well, I cannot tell you what other lawyers cost, but I can tell you what I cost. And I can tell you what happened when one dad said, I want everything to go to my son. He didn't want it to go to his other children. He wanted it all to go to his son, but he didn't do it right. He thought he was smart enough to do it without a lawyer and have everything go to his son, but it turned out that it went to all the children because, as I said, he didn't write his will in a proper way. He left an estate, I think it was about $400,000. Now, he could have paid me $1,500 to do a will and powers of attorney, and then everything else, $3,900, don't make me do the math, y'all figure it out. 400,000 minus 1,500. It was a lot of money son could have got, right? But he didn't get it. He had to share it with his siblings because dad didn't want to pay a lawyer $1,500. Again, that may sound self-serving, but truly there are many hurdles to doing a good job on a will. And if it's not something you do regularly, it could be easy to be tripped up. I have a paralegal who always says, if you wouldn't cut your own hair, don't do your own legal work. And I think that's a good standard because you know what? Your hair grows back. And if you wouldn't dream of cutting your own hair when it grows back and you could have a professional do it later, why would you dream of doing your own legal work, which you don't get to come back and fix? Okay, so we talked about powers of attorney. We talked about DNRs. I know I was supposed to talk a little bit more, but I see there have been a lot of questions. Maybe we should take some questions. Would that be okay?
I think that's a great idea. We got lots of questions. And since we're still on the topic, they'll be fresh. So let me scroll up here to the top. Okay, I'll just start here. Let's see, I did a POA and an MPOA with an attorney. But as time has gone on, if I want to change those people, can I just cross out the names and write in the name of the new one, or do I have to go back to the attorney?
Well, I know it seems like a waste of money to have to go back to the attorney, but crossing out and writing in is not the way that we do a change to a power of attorney. So I would go back and pay to have them done again. I'm sorry.
Okay. Let's see. If a POA agent is not physically able to sign paperwork on behalf of a patient or client, can the alternate with verbal consent from the agent sign on behalf of the patient or client?
Okay, that's an interesting question. Let me make sure I'm understanding. You have
Joanne Hernandez.
You have the patient who is the principal on the POA, and the principal appointed, let's say, Carol as the primary, and Carol can no longer physically sign. Can Carol authorize the alternate to sign? That is a good question. I think the easiest answer would be for Carol to resign and the alternate to serve. But if that's not satisfactory, I think that would be probably the best solution. But we could talk later about it. But I think that's a dangerous situation.
Wow. All right. We're like trying to play stump the lawyer, aren't we?
Yeah.
Okay.
Easy to do.
Um, let's see. How long does probate take? And where do you take it? What happens? Like if I was somebody's executor, I have their will, it's physically in my hands. What do I do with it?
Okay, the best thing to do with it, y'all are not going to believe me when I say this, is take it to a lawyer. Oh boy. But when you do a probate, you have to be represented by an attorney unless you're the spouse and you're the sole beneficiary. In Bexar County, at least, you cannot probate your own will. You have to have a lawyer do it. So you take it to the lawyer in the county of where the person died. You don't have to go to the lawyer in that county. You can go to a lawyer anywhere, but the probate is going to be in the county where the person died. And the lawyer is going to proffer the will to the court, the probate court. So it's going to end up with the court records, or in the court records. It becomes a public record. And sometimes people don't want to do a will because they don't want that will to be public, and instead they do a living trust because they want that their disposition of their estate to be private. But when you do a will, it does become public record.
So just to clarify, so if let's say somebody died in Dallas and I live here, and I'm the executor, I have to go to Dallas and find a lawyer?
You don't have to. You could use a lawyer here, but what I would do actually is to call a lawyer here who you trusted and ask for a referral in Dallas, because it's going to be cheaper for a Dallas lawyer who knows the Dallas County rules to handle that probate.
Wow. I did not know that. Okay. And how long does it usually take?
Oh, that's a great question, and it really depends. So a simple probate where we have a spouse and there's a house and maybe some bank accounts and an IRA and a car and other assets like that, we can get done in, say, 4 months. But if you've got numerous beneficiaries and you've got a house to sell, like maybe it's mom and she's died and we've got all the children and we've got to sell her, we've got to clean out her house, we've got to sell her house, we've got to gather up all the bank accounts, sell the car, we can talk about a year.
Wow. That's crazy. Let's see. What if someone writes in, I've seen this on some of my patients, they've written in per law. Like,
Per law.
yeah, I want and sometimes it's handwritten, I want my estate and my belongings to be divided per law.
Oh, okay. Well, by that they're saying that the if you die without a will in Texas, somebody's still got to get your stuff.
Right.
So there's a law that sets out who gets what. For example, if you're married and all of your children are also the children of your spouse, then your community estate passes to your spouse and your separate property passes partly to your spouse and partly to your children. But let's say that you're married and you've got children from another relationship who are not the children of your current spouse and you die without a will. In that case, your share of the house goes to your children, not your spouse. And that can be a very unpleasant situation.
Why does the house go to the children?
Because if you wanted it to go to your spouse, you could have written a will.
But by law, does it have to go to the children and not the spouse if she lives there?
And she lives there, but she does have a surviving spouse homestead right, which means the kids, even though they own half the house, can't kick her out for her lifetime. but you've still got an awkward situation where if she's not keeping the house up, they're going to be complaining, hey, you're not taking care of our asset.
Wow. Boy, it gets very complicated, doesn't it?
It does.
Okay, from James Edgar. Do you need a will if you have a living trust?
You always need a will because it's possible there's something that you forgot to put in your living trust. And I was just talking to a lawyer today, and she was saying that she had never seen a living trust that didn't have to have the will probated because somebody forgot to put something in. I have a case right now where we've got, I don't know, several $1 million in the trust, and there's an account out there for $78,000 that they didn't put in the trust. So we're probating that will because of that $78,000. So you always have a pour over will, meaning it pours over into the trust. But if you have everything in the trust, you don't have to probate that will.
Wow. Is it possible, this is from Mary, is it possible to have a secret will that leaves your share to the boyfriend without your husband knowing?
Well, your husband won't know until you're dead. But after you're dead, husband's going to know.
Darn, okay.
And I'll tell you, there's a lot of surprises that spouses find. I mean, not necessarily in the will, but let's say I've had spouses find out that there's extremely high credit card bills for online porn that they didn't know spouse was involved in. But when you die, all that keeping things secret is hard to do because you're not there.
Okay.
Yeah, happy thoughts.
Let's see. I did. Okay. Do you recommend someone to do a will if they have no assets, no value, no money in the bank?
Okay, you're going to love this. I recommend that everyone have a will because you never know what's going to happen. And here's an example. I had okay, let me make sure I'm getting it because it's confusing. I had sister die without a will. And a part of her estate passed by intestacy by the laws of descent and distribution to her sister. But her sister had predeceased, leaving a son who had died. Son didn't have a will, and so his beneficiaries were his mom and his dad. Well, his mom was alive, so dad, and his mom was dead. So dad, who is the brother-in-law of my lady over here, inherited part of her estate. Very unusual, because usually an in-law cannot inherit, but he inherited because his son, who was deceased, had died without a will, and dad was an heir. Okay, so even though you don't have anything, you never know when your mom's sister is going to die intestate and leave something to your dad. In other words, you never know what's going to happen. You might as well have a will. It doesn't have to go through probate if you die with nothing, but you might as well have a will.
Might as well. Somebody may leave you something, right?
You'll never know.
Okay, this is from Robin. What happens if the person designated as the executor of the will dies? Does a new will need to be created with a new executor designated? My understanding was a will cannot be altered with physical markings. What are some of the challenges when there's no executor?
Okay, great question. You're right. You do not alter the will with writing on it. You do not do that once it's been executed. However, when you do your will, you're going to name a primary executor, an alternate, and even a second alternate, just like with the powers of attorney. So if your primary executor dies, you don't have to do a new will. It just goes to the next executor. Now, if you did a will with only one executor, yeah, you're going to need to do a new will because your executor is dead. If you don't, we have to do something at your death called an administration with will annexed, and we have to have someone appointed as administrator. This is more expensive and more difficult and more complicated. So you should do a will with several persons named as executor, I mean.
Okay. Can a relative be a power of attorney if the relative is an inheritor?
Yes. Yes, you can appoint someone to be your agent under a power of attorney, and they also can be a beneficiary under your will.
Can they also be your medical power of attorney and pull the plug?
They can, so you've got to trust them.
Let's see. We have a question from Edwin. What happens when someone hasn't appointed a medical power of attorney and isn't able to make decisions regarding his care?
Great question. So if you're in the hospital or a nursing home or jail, but primarily hospital or nursing home, and you don't have a medical agent, the Consent to Medical Treatment Act says that we can look to your spouse first, then your adult children, then your parents, then your next of kin to make medical decisions for you. But if you're at home, the Consent to Medical Treatment Act doesn't apply. So, but if we got to a really bad situation, you'd end up in the hospital or in the nursing home, and we'd go to the Consent to Medical Treatment Act. But you really want to have a medical agent so that guardianship is not necessary if we need to make medical decisions for you and you're not seriously ill.
Yeah, I had an interesting case once where I had a woman who had no children. Her spouse was deceased. She appointed a medical power of attorney, and she appointed just a power of attorney for the legal and the finances. Now, these two people did not get along.
Oh.
Okay. So my patient became incapacitated, and there was a decision made whether she was in the hospital, whether to move her back home under care, which was what her medical power of attorney wanted, but her power of attorney wanted her in a nursing home. And so part of us thought the medical power of attorney should have made that decision because that was kind of medical, but it ended up the power of attorney, the POA, got to make that decision because it was a financial decision.
I think that's a really great scenario.
Mm-hmm.
And ultimately, I don't remember what the financial power of attorney, the statute sets out all the things that the financial power of attorney can do. And I don't know if determining placement is in there, but the ultimate decision is really up to the financial agent because they're the ones who pay the bills.
Yeah. Yeah, it was very sticky icky.
Yeah.
Yeah. Okay, I have a question from Mary. My mom died and left everything to my 3 siblings and me. Her will states that we divide everything evenly. Her home is filled with antiques, and we promised her that we would keep them in the family. How do you recommend that we go about dividing all of these items evenly among the 4 of us?
Okay, well, there's a couple of different things we could do. One thing we can always do is just draw straws, and then the person who draws the shortest straw picks first, and then the next person picks, and the next person picks, and the next person picks. And then we go back and start again and go around, okay? But some people don't like that because it means, well, the person who drew the shortest straw picks the most expensive item, and then they get more. So another way we can do it is to value everything, and then we draw straws, and then we equalize the estate. So if you pick the most expensive item, and I ended up with items that were $20,000 less, well, I get $20,000 more cash to equal out what you picked, okay? Or we can set the testator, the person who did the will, can say, you know what, I'm going to have the executor make the final decision based on, okay, you want this and you want this, but executor makes the final decision. There's different ways we can handle it.
No, that's never fun either. Okay,
No.
let's see. Does a will need to be registered at the courthouse? That's from Arthur Dawes.
Not at the time that you write it, but after your death, we take it to the courthouse to probate it, to probate the will. That's when it goes to the courthouse. You can place it for safekeeping at the courthouse for $5 if you don't have a safe place to keep the will, or you're worried that your relatives are all going to come into the house after the funeral and take the will away. So you can place it for safekeeping at the courthouse, but then it's not public until your death.
And when you say made public, where do you find those records?
Well, some courts now have them online, but they're at the courthouse.
At the courthouse. Okay. This is from Kim. If you have a will in place, how often do you recommend reviewing it to make sure it's current and everything and everyone is covered?
You should review your legal documents anytime something happens that makes you really happy or really sad.
That's great. Okay, here's another question from Kim. Is it common for spouses to have separate POAs? If a couple were to die together, for example. Oh,
say that again?
Can you hear me?
Yeah,
Okay.
I'm sorry, I
Is it
missed
common?
on.
Okay, is it common for spouses to have separate POAs? So a husband and a wife have separate ones. If they were to die
Yes.
together, for example, in a car accident, how would the two separate POAs have to work together for their combined assets?
Okay, remember that the POAs are only for lifetime. So you're going to have separate, everybody's going to have their own will, their own financial power of attorney, and their own medical power of attorney. And they can name different people to serve in all of those roles. Okay. But if you die together, your wills are going to say, and you can name the same alternate executor if you want, and that person can probate both wills, or you can name your sister as your executor and he can name his brother as his executor. And then they're going to have to work together to probate the estates, divide up the assets, and distribute as per the will. Does that answer the question?
Yeah, but it could get really muddy. What if I decide my house goes to my children and my husband decides it goes to his girlfriend?
Well, his half goes to his girlfriend and your half goes to your children.
Wow.
So we've got to sell the house. So we've got two people deciding what the house is going to cost and accepting the sales price and all of that.
Mhm.
And then the house sells, half of it goes to his estate, half of it goes to her estate and gets distributed.
Wow. Okay. From Edwin again. Is it a good idea to have the executor name the attorney who helped with the will? Does it expedite the process?
That's a great question. I think it's usually best to let your executor choose their own attorney, but you can certainly, I certainly appreciate it when the testator leaves my card with the will and says, hey, you know, this is who I used and I was satisfied with her service. That way, if the executor doesn't know any lawyers, at least they have a starting point.
Mm-hmm.
There are lawyers who write it in the will, and my executor shall use so-and-so to probate the estate, which I don't think is binding and is a little bit overreaching, I think.
Yeah.
So I think that the executor should have the right to choose whoever they want.
Yeah. I think it's a nice it sounds helpful to me, like someone put your card, like for me to put my your card in my will saying, this is who I used if you don't have anybody. Yeah, I like
Yeah,
that.
yeah, it's helpful.
Okay. This is from Joy. I had a patient that near the end of her life, she started giving out items to friends and family. Her son from out of state came in a couple days before she died and became very upset and demanded that everyone bring the stuff back. He was the executor of the will, not the POA. She was no longer alert or verbal when he came, and it was awful. Can the patient give away stuff if they want to before they pass?
Absolutely. Absolutely, they can. It's a real fine line, though, because it's possible that the patient's capacity has diminished. So apparently, Son felt that she wasn't, or I don't know what Son felt, but attributing the best of motives to him, he felt that she didn't have capacity and was doing things that were not in her best interest. But absolutely, if you have capacity, you can do whatever you want.
Yeah. What would your legal advice have been to him? If he came to you and said, she gave away all this stuff and I don't think it was right. And what should we do? I want it back.
I think I would have questioned him carefully about what was given away and to whom. And, if it was caregivers who she'd never met before, who had just come in at the end of life to take care of her, and she was giving things away that were highly valuable or sentimental family items, I would have said, okay, well, that's suspect, But if it's her old friend from 50 years and she gave away a sentimental item, well, then no, that's her friend.
Kind of assess the intent.
Yes.
If
Yes.
Yeah. Okay. Last question. I had a patient near the end of her life. She started. Oh, that was the same one. Okay. Okay. Here's another question. This is from Robin. Regarding the 2 witnesses required on the various advanced directive documents. The instructions regarding witness says one cannot be your healthcare provider or executor of the estate or a relative. Does this mean the person identified as the second witness may be a relative, healthcare worker, and executor?
Exactly. On those documents, and you can also do them with a notary instead of witnesses. The one I sent out just has witnesses because that's usually easier for people to find. But you've got to have one disinterested witness. The first witness must be disinterested. The second witness can be anybody.
What about the out of hospital do not resuscitate? We always go back and forth on this. We have 2 witnesses on that document as well.
That's true. I think that the DNR says they've got to be the same as, they've got to meet the same standards as for the medical power of attorney, doesn't it? Which means one disinterested witness.
Okay.
I personally like to notarize all the documents because I'm a notary and that's simpler. And then you don't have to find witnesses.
Mm-hmm.
But in those situations where you don't have a notary.
No, many times we draw these documents at the admission of hospice. And
Yeah.
you have to go find somebody. And, for all of you out there, sometimes it's very muddy. I run into this all the time. I'm in the hospital and I'm about to admit a patient for GIP, or we're going to move somewhere. So I have to have an out of hospital DNR. And to go around and find 2 witnesses, at 11 o'clock at night, or just even 2 witnesses who aren't part of the medical team. We're going to find other family members from roommate, or we're going to find a housekeeper. It's crazy.
Yeah.
Yeah. All right. Well, gosh, it's 7:27 already. Our time is up. That is insane.
Oh, well,
We're going to have you back.
Oh, I'd love that.
This was just beautiful. And I hope everyone learned something tonight. I know I did. And I'm going to have to get my will out and look at it now. Because, yeah, it's been a while since I've looked at it. But I sure appreciate this, Carol, and it was wonderful. Thank you. Thank you.
Oh, thank you.
So everyone, tomorrow you're going to receive a survey, and just, please fill it out, please, please, please. And that helps us plan for our next ABODE Academy. And we also want to invite you back next week, next Thursday at 6:30, back on Zoom. And we're going to hear part 2 of this topic called A Good Death Is Your Life in Order. Our speakers are going to be Arthur Dawes, former social worker, naturalist, ABODE volunteer, and a coordinator for Pax Christi, a social science advocacy group. And then Darwin Howardson, a community coordinator for Porter Loring Mortuaries. And the question will be, if we die tomorrow, does anyone know where to find our keys, our financial records, account codes, passwords? What about your will? And that's the big problem. I don't think anybody who I signed on knows where my will is. So, yeah. So, one of the most important things we can do to prepare for our death is to get organized. So they're going to get us organized next week. So I hope you all enjoyed this as much as I did. And Carol, again, thank you. Very informative. All right. Have a good night, everyone. We'll see you next week.